Hi, my name's Kate Silburn and I own Rocky Mountain Elder Law. And today I want to touch on the subject of advanced directives for medical or surgical treatment, otherwise known as a living will. The living wills that I do for my clients involve three scenarios. The first is the terminal condition, an incurable condition where by the cessation of life support would mean you would pass away. A terminal condition is when you are effectively brain dead, you are non-responsive, non-communicative. And when we say life support, I want you to think about a respirator or a ventilator, but for that ventilator or respirator, you would pass away. The next scenario in a living will is a persistent vegetative state. Think of that as a long-term coma. And then finally, in my advanced directives, I contend with COVID and its variants. Why? Because we're still contending with COVID in our society, and it is still an issue when you present at an emergency room with COVID. I don't want your advanced directive to limit the days on a respirator. Why? Because with COVID, we can do very well on a respirator for an extended period of time and recover very nicely. So those three scenarios are in your living will. Why do you need to plan for them? I hope that you never have to use your living will, but it's a kind of insurance. And the theme that I have throughout my estate planning is let's make every choice we can, while we have capacity, while we have the ability to make those difficult decisions. The utmost point I want to make about a living will is that you relieve the people who love you from the burden of making the most difficult decision. With that, I am happy to speak further on this in subsequent videos, but that kind of gives you the lay of the land on an advanced directive or living will, and I hope that you tune in for more information. Thank you.